In this video, I will talk about my ownership documents for the new computer technology I have discovered. I introduced this technology in 2013, and I did my PhD dissertation on this topic. A couple of years later, in 2015, I finished the PhD program, but the University of Alabama delayed my dissertation defense, and it was due to the importance of this technology. I did not give up on my ownership, and the university unlawfully delayed my graduation. In 2017, I got some support from Governor KIV. She assigned her legal counsel to resolve the issue. The legal counsel for governor was Mr. Brian Taylor. He was a former state senator, and he started a series of communications with me and with the university. These communications were very effective in resolving the ownership issue. Also, I had to hire an IP lawyer. It was just after I rejected the offer for faculty position that I asked from my lawyer to start the legal proceedings. The second offer for the faculty position was on June 28th, and my lawyer sent a pre-litigation letter to President Bell on July 11th. Let's see that document.
Kobler IP, Intellectual Property Law, July 11, 2017. Regarding Ali Amiri. Disclaimer of ownership in research work. Dear Dr. Bell, I represent Mr. Ali Amiri, a PhD candidate in the Department of Physics and Astronomy. The reason for this letter is to request that the University of Alabama expressly disclaim ownership of certain work conducted by Mr. Amiri in preparation for his PhD program. The relevant facts are as follows. February 2015, Mr. Amiri submitted a proposed research plan to his dissertation committee, which included, among other topics, a proposal to do an experiment to develop a memory device based on VO2 films. A copy of Amiri's proposal is enclosed, and the relevant portion of the proposal is found on page 22. Mr. Amiri has successfully defended his research plan on March 6, 2015. Mr. Amiri has been in contact with the Office for Technology Transfer, OTT, for more than 6 months starting from January 2017 to discuss possible protection of his idea through the University of Alabama. But his advisors did not agree to undergo the formal disclosure process in accordance with the university's patent policy. Furthermore, the University of Alabama did not permit Mr. Amiri to conduct experiments to develop such a memory device since its proposal in February 2015. I have enclosed a simple disclaimer form. I request you sign indicating the university's disclaimer of ownership in Mr. Amiri's concept for a VO2-based memory device. Please return the signed document to me at the address above. Thank you in advance for your attention to this matter. If you need further information, please feel free to contact me by email or by phone. Best regards, George P. Kobler, Kobler IP, LLC.
At this point, I had two leverages. My lawyer had started the legal proceeding, and the Office of Governor KIV was demanding that the university follow the law. The university evaluated the technology and created a report. I will show you 2 pages of this report. The first page is about the market value of the technology, and the second page is about the potential customers. This report was created by the experts of university. I did not provide this information to them. It was based on their own resources, and it was based on their own information.
Market. Memory Management Unit Manufacturers. Revenue, $574 million. CAGR, 5.6%. Microcontroller Manufacturing. Revenue, $610.5 million. CAGR, 5.6%. Non-volatile memory application. Revenue, $21.6 million. CAGR, 60%. Circuit elements with memory. Revenue, $529.6 million. CAGR, 67.8%. Explosive growth with increased demand for efficient and expansive memory systems. Potential customers. Hewlett-Packard, revenue, $18 billion. Cadence Design Systems, revenue, $2 billion. Texas Instruments, revenue, $13.37 billion. Fujitsu Semiconductor, revenue, $22.51 million. Western Digital Corporation, revenue, $12.99 billion. Toshiba Corporation, revenue, $54.65 billion. Crossbar Incorporated, revenue, $3.28 million. HGST Incorporated, revenue, $958 million.
The Intellectual Property Committee reviewed the report. The IP Committee had 10 members, and all of them unanimously decided that I was the owner. After that, the Office for Technology Transfer officially recognized me as the owner of the technology. To confirm my ownership, the university had to release all of its invention rights and interests in the technology. Let's see that document.
Agreement for release of invention rights. Whereas, Ali Amiri, referred to herein as inventors, have conceived and disclosed to the Board of Trustees of the University of Alabama for and on behalf of its component institution, the University of Alabama acting by and through the Office for Technology Transfer within the Office of the Vice President for Research and Economic Development, UA, Invention Disclosure UAIPD 17-0043 entitled Memory Device, referred to herein as invention, the substance and entirety of which is attached hereto as Exhibit A, and whereas, rights of the inventors and UA in the invention are governed by the terms of the University of Alabama Board Rule 509 and UA Patent Policy, as approved by Board of Trustees in February of 2013, and whereas, the invention was conceived and/or reduced to practice under conditions such that it is the property of UA under the terms of the UA Patent Policy, and whereas, pursuant to the UA Patent Policy, UA has determined that it has no interest in retaining ownership of the invention and that it is willing to release to the inventors UA's interest therein. Now, therefore, the parties hereto agree as follows. Paragraph number 1. UA hereby releases and transfers to the inventors and to their heirs, executors, administrators and assigns all of its right and interest in and to the invention as described in Exhibit A and in and to any and all copyrights and/or patents, whether United States or foreign, which at any time may be granted therefor, including any and all renewals, reissues and prolongations thereof, the copyrights and patents. Paragraph number 2. The inventors represent that they are the only inventors of the invention. The inventors further agree that, if other individuals contribute to the invention, then it is the responsibility of the inventors to obtain assignments of the rights of the additional inventors to the inventors to secure full ownership and control of those additional contributions without cost to UA. The inventors hereby grant to UA a perpetually irrevocable, non-exclusive, non-transferable, royalty-free license to practice said invention internally for educational and research purposes only. Paragraph number 3. Inventors agree to indemnify and hold UA and its trustees, directors, officers, employees and affiliates harmless from and against any and all claims, demands, losses or causes of action related in any way to the production, marketing or commercialization of the invention. Paragraph number 4. Inventors understand that said invention is being assigned to them for their own personal activities. UA does not have any responsibility to further develop the invention, and UA shall not be obligated to expend any additional funds, equipment, facilities or other resources. Inventors agree not to use any UA funds, equipment, facilities, or other resources to patent, market, license, sell or otherwise commercially develop said invention after execution of this agreement without UA's prior written approval and full reimbursement of the costs of such use. The foregoing notwithstanding, inventors are free to perform continued research relating to the invention. The rights of inventors and UA in any improvements to the invention that fall outside that described in Exhibit A or new inventions stemming from this continued research that fall outside that described in Exhibit A will be governed by the terms of the UA patent policy. Paragraph number 5. Except as otherwise expressly set forth in this agreement, UA, its trustees, directors, officers, employees, and affiliates make no representations and extend no warranties of any kind, either express or implied, including but not limited to warranties of merchantability, fitness for a particular purpose, validity of patent rights claims, issued or pending, and the absence of latent or other defects, whether or not discoverable. Nothing in this agreement shall be construed as a representation made or warranty given by UA that the practice by inventors of the invention granted hereunder shall not infringe the patent rights of any third party. In no event shall UA, its trustees, directors, officers, employees and affiliates be liable for incidental or consequential damages of any kind, including economic damage or injury to property and lost profits, regardless of whether UA shall be advised, shall have other reason to know, or in fact, shall know of the possibility. Paragraph number 6. This agreement shall be governed by the laws of the state of Alabama. In witness whereof, this release and assignment has been duly executed by UA and the inventors, as of the date set forth below. Inventor. Signed by Ali Amiri. Date, 7 August 2017. The University of Alabama. Signed by Carle Pinkert, Vice President for Research and Economic Development. Date, 7 August 2017.
There were 2 professors who had access to my data, and they knew the details of my discoveries. One of them was the Associate Director of the Mint Center. He was Dr. Arunava Gupta. The other person was the chair of the physics department, Dr. Patrick Leclerc. These 2 people had to disclaim any right for ownership, but they were refusing to do so. It took some more legal work to get them to sign the ownership disclaimers.
Disclaimer of ownership rights. I, Dr. Patrick Leclerc, hereby expressly disclaim all ownership and interest in the work of Mr. Ali Amiri relating to a VO2-based memory device. I made no contribution toward development of the concept or to the reduction of the concept to practice. Signature. Patrick Leclerc. Date, 17 August 2017. Disclaimer of ownership rights. I, Dr. Arunava Gupta, hereby expressly disclaim all ownership and interest in the work of Mr. Ali Amiri relating to a VO2-based memory device. I made no contribution toward development of the concept or to the reduction of the concept to practice. Signature. Arunava Gupta. Date, 17 August 2017.
These 3 documents completely prove my ownership of the new computer technology. And after that, I filed several patents and I started a company. Let me explain what is the importance of these documents and why I spent several years and a lot of money and resources to get these documents. Let's say you buy a house. You pay a lump sum of money at first, and then you pay mortgage for 10-20 years, and then you become the owner. Somebody shows up with a gun and kick you out of your house. What do? You go to the government, and the government not only returns your house, but also prosecute the thief. If you buy a car and somebody steals it, if you know the thief, you go to the police, and the police should arrest the thief and return your car. That is what is expected. This technology is the result of more than 20 years of my work, and I spent several years to get the ownership documents under the laws of the United States. For instance, the paragraph 6 of the Agreement for Release of Invention Rights reads, "This agreement shall be governed by the laws of the state of Alabama." I expect that the US government should protect my ownership rights All of these documents were issued in the United States, and the US government should respect and protect my ownership.